Hi, and welcome to the show. Subscribe at kevinmd.com/podcast. Today, we welcome back Tracy Liberatore. She is an attorney and former physician assistant. Today's Kevin MD article is Unavoidable Pressure Ulcer Claims Live and Die by the Record. Tracy, welcome back to the show.
Thank you. Great to be back.
All right. So, for those who didn't get a chance to read your article, tell us why you decided to write it and then about the article itself for those who didn't get a chance to read it.
Yeah, so interesting. I actually had an attorney request for one of our experts and ask if we did this FNHRA regulations. And when it came through, the expert wasn't really sure what that was. So I ended up going down a rabbit hole trying to research it myself so that I could help the expert understand it and also my other experts. So I decided to write the article because it wasn't something we were very familiar with. We normally use F tags. And so basically, the article is about that and the documentation. So pressure ulcers, there's different tests that the experts have to look at when they're going into, and there's the plaintiff versus the defense, and defense always wants to claim they're unavoidable. And of course, plaintiff wants to say certain things weren't done. And it often sounds like it's an argument over these ulcers, but it's really an argument over documentation and what rules are in place that were violated or not violated. So I kind of think that's the long and short of it.
All right. So I know you do a lot of expert witness work. So what are some of the more common scenarios where pressure ulcer scenarios find themselves into the courtroom?
Yeah, so what we see a lot is on the plaintiff side, typically, there's issues with either nutrition, turning and repositioning. And so, of course, as I said, defense wants to say these things are unavoidable. So, the four tests that for prevention and unavoidable ulcers is if the resident's clinical condition and the pressure ulcer risk was evaluated, what interventions were put in place and implemented and consistent with the resident's needs. They need to look at interventions if they're monitored and evaluated for the impact, and then if these approaches are revised as appropriate for the resident. So those are really the 4-point test. And then there's these different layers now, as I said, with the FNHRA, there's the F tags, which are the federal rules. And then the FNHRA comes in for a publicly owned company only. So those are the different things that I've discovered that our nurses need to really look at, either ask the attorney up front, if this is a public or a private owned facility. I think I said that backwards, actually. The FNHRA is for publicly owned nursing homes, sorry, not privately owned.
So, in terms of the plaintiff's reasons for bringing a case like this in a courtroom, what are the most common reasons why they would allege any malpractice? Like, what are some reasons that brings it up to the plaintiff's attention and bring it into a legal situation?
Yeah, so usually it's a family member that's going to bring these claims because mom or dad was in a nursing home and they felt they weren't being cared for. And so, family members that see these ulcers growing, sometimes they can look very, very hideous. And I mean, they just take over. Some people get referred then out to the hospital and they can be septic. It can go into the bone. And then, ultimately they can die from these things. So when a family member sees their loved one developing these ulcers, obviously they're going to assume that they weren't being cared for. Toileted, are they on a schedule for that? Are they being turned and repositioned? And so again, family members don't understand the different factors that come into play as far as nutrition, lab works, different things that nursing has to look for. But if they come in and they visit a family member and they find their family member sitting in urine and feces, and then they grow an ulcer, you better believe they're going to feel that something wasn't being done right at the home.
So take us into the courtroom, and you did mention this, the 4-step F-tag test, and what that test does, it defines whether a pressure ulcer is clinically unavoidable versus avoidable. So let's unpack that a little bit. Tell us about what those 4 steps are in a little bit more detail, and how is that typically argued in the courtroom?
So unavoidable. So the resident's clinical condition and pressure ulcer risk is something that the home has to evaluate when the resident is admitted, typically within a certain time frame. And again, these are part and parcel of the rules that the experts need to be aware of, policies and procedures within the facility. But so they need to really be assessed. They need to do a skin assessment. They may be admitted with a pressure ulcer. If you don't look at the skin when the person comes in and document it, you wouldn't really know. And risk factors would be, are they diabetic? Are they, do they have vascular disease, and different things that could play into those factors. And so then interventions, as I said, like the diet, the nutrition, the turning and repositioning, are they monitoring labs? Are they bathing the patient? Are they making sure they're on a toilet schedule so that, they can get them in up and out of and cleaning them and the different things like that. And then so monitoring these different interventions when you put them in place to make sure that they're working. Is the ulcer healing? Is it not healing? And then, revising as necessary. So, and sometimes wound care really needs to be consulted to come in and look at these wounds and debride them and treat them and take care of them. And they may need to go out and have them surgically debrided. It's just, there's a lot of different factors that go into that. And really, a lot of the wound care documentation we see, they're documenting sloughing and tunneling and all these, there's so many different things that go into staging the ulcer itself. But really, you want to see the ulcer coming down in stage and not going up. But there's a lot that goes into looking at these ulcers.
And in terms of applying those four steps, are there gray areas which leads into contention in the courtroom, or are they pretty much black and white?
There's always gray areas. I mean, again, that's why we have these things that they end up going to court, right? Because as I said, defense is going to argue, well, it was unavoidable because of X, Y, and Z thing, that this patient had comorbidities. And then so really it boils down to the documentation to show whether or not the staff was doing what they were supposed to be doing. And unfortunately, a lot of times we don't see the documentation. And so if it's not documented, was it done? Was it not done? I mean, those are the arguments that come up.
And when it comes to documentation, just tell us what is appropriate documentation to document these four steps and why are they commonly missed?
Yeah, so I would say they're commonly missed. Probably either number one, they're not done because of low staffing, or they're not documented because of the same problem, short staffing. And it's hard to, patient care plus documentation. And so they need to document, what interventions are in place. And then the nursing has to document every time something is done. So you look at a turning and repositioning schedule, if it's usually every 2 hours, nurse has to go turn a patient and write down that they did it. They usually have to initial in the graph that's in the chart.
Now, things like age, comorbidities, and frailty, they're not automatic justifications for unavoidable pressure ulcers, right?
Right. No.
So they simply have to go with those four steps. So I just want to make sure I have that correct.
Yeah, no, absolutely. Because those are the things that they'll try to argue as to the reasons and contributing factors, but that does not excuse not treating the patient with these four different factors. So it becomes unavoidable if you've done all four of these things and the ulcer still grows because of comorbidities. But if you don't do any of these things, of course, these ulcers are going to grow, comorbidities or not.
Now, just tell us some of the outcomes of these trials. Like you said, in that first scenario you mentioned, a family member brings a perceived lack of care to a plaintiff attorney, and they bring the nursing home into court, and then you have this legal battle over pressure ulcers, whether they're unavoidable or not. What are some of the outcomes of some of these trials, and what are some of the repercussions that these nursing homes can face if they don't document this correctly, end up losing these cases?
Yeah, so we see most of the cases in these issues will settle out of court. So I don't necessarily know what the settlement numbers are because those are behind closed doors. But some of the bigger cases that we've been on have had issues where they can go then to a second trial. After the first trial is settled on the negligence, they could go to a second trial on like punitive damages. And in those instances, what they're really trying to show is global negligence of this entire facility, that they just really failed this patient. And right now we're part of a litigation where there were multiple patients involved in this one facility, and they're showing each individual person kind of what happened to them, laying it out so that it can really show the global negligence of this facility as a whole.
In your article, you talk about a 2023 Supreme Court decision that affected this particular issue. So, for those who didn't get a chance to read it or certainly not familiar with this particular court case, just tell us a little bit about that.
Yeah, so that's the Talevski case that I was talking about. And this is where the FNHRA provisions sort of came in. And this, again, is for the publicly owned nursing home facilities. I actually just did an update to my course based on this whole ruling, so I went a little bit into depth. But so these, again, it's the publicly owned. It came through on an issue with finances, and then it ended up coming through as this rule. So again, it's something that is available in certain instances. Most likely your attorney will tell you if it's an instance, but as an expert, it would be something to just really be aware of, because if the attorney's not aware of it and you bring that to them, you're going to look like a hero for them. So it held basically that the FNHRA rights are enforceable under Section 1983 at publicly owned facilities, that the chain is no longer just an administrative compliance reference, and it's enforceable federal civil rights with its own litigation pathway is what makes that a big deal.
All right. Now, what are some messages for the clinicians if they're rounding on nursing home patients and specifically about pressure ulcers? What are some lessons that they need to take home from this?
Yeah, I mean, the biggest thing is if you're doing something for the patient, make sure you're documenting it. Because again, in the legal world, we look at it and we say if it's not documented, it wasn't done. And there's really no way to come back and prove that it was. If it's not in your notes and it's not in the chart, you know.
We're talking to Tracy Liberatore. She is an attorney and former physician assistant. Today's Kevin MD article is Unavoidable Pressure Ulcer Claims Live and Die by the Record. Tracy, as always, let's end with some take-home messages that you want to leave with the Kevin MD audience.
Yeah, again, it's just, documentation, documentation. And for me, if you're, an expert, really just making sure that you know the status of the home, what rules are involved for your case, make sure you're laying that all out for your attorney and applying your analysis to those rules.
Tracy, thank you again for sharing your perspective and insight. Thanks again for coming back on the show.